By the power vested in me by the state, I now pronounce you man and wife. You may kiss the bride.
Mom, Sally's had the baby. It's the most beautiful girl you've ever seen. Yes, Sally's fine. She's doing great.
All right, Fred, that's it. I want a divorce. I'm not going to put up with any more of your excuses, you...
Marriage, children, and divorce, milestones in more and more American lives. On this tape, we're going to talk about family law. It's divided into 4 main sections: getting married, being married, children, and breaking up. This is a large and important subject, and we're going to cover a lot of material. These legal issues will touch many of us at some point in our lives, and the information you'll hear next could be vital to you and your family. Although we'll talk about various kinds of relationships, it could be said that every traditional family begins with a marriage. So let's first define that term. Marriage is both a contract between a man and a woman to become husband and wife, and it's an important social institution. Like any private contract, marriage grants rights and imposes obligations on the 2 parties. But because of its importance to society as a whole, the law in most states doesn't allow people to enter into marriage without a license and a ceremony performed by an authorized official. Society recognizes marriage as a financial partnership, a sexual partnership, an arrangement for raising children, and a source of emotional support.
Marriage exists in one form or another in every society. It predates the religions and governments that sanction it. Today, marriage law recognizes society's interest in the relationship in many ways. It puts limits on who can marry and how much the partners can modify their relationship by contract. The law also recognizes the religious role in marriage by authorizing clergy to perform marriages. It also allows the clergy full discretion to decline to marry couples who don't meet the religious standards of a particular denomination.
There are 4 major restrictions relating to marriage. Number 1, you can't marry someone of the same sex.
There has been talk in some states of affording same-sex couples a way of formalizing their commitment. But as of January 1992, a legal marriage is always between a man and a woman.
Number 2, you can't marry someone who's already married. That's bigamy, and the later marriage is void. Number 3, you can't marry someone who's underage.
The age at which you can marry without parental consent ranges from 15 to 21, with 18 being the most common. The minimum age is lower in most states if you have a parental permission. California has no limit if your parents agree to the marriage, and in several other states, the minimum age is just 14. Many states will make certain exceptions to their age of consent in special circumstances, such as if the bride is pregnant.
And the 4th restriction on marriage is you can't marry certain close relatives.
The rules vary, but all states prohibit parent-child, grandparent-grandchild, brother-sister, or aunt or uncle, nephew, or niece marriages. Most states also forbid marriage between first cousins, and some bar marriage between other relatives.
We know who can and can't get married. Now we'll discuss the 2 steps involved in becoming husband and wife. First, getting a license, and second, having a ceremony.
To obtain a license, one or both parties must apply to the appropriate state or local office and pay a fee. Many states require a blood test for one or more venereal diseases, a general physical, and/or a German measles vaccination before a license will be issued. Many states also have a waiting period of 2 to 7 days between the time the marriage license is applied for and issued. After you get the license, the couple must be married by someone legally authorized to perform marriage ceremonies. This is usually a member of the clergy or a judge. The ceremony varies greatly, but all the law usually requires is that the man and the woman agree to marry each other. It may not even be necessary to have a witness other than the person performing the ceremony. The couple is married when the ceremony ends. The official conducting the ceremony is responsible for recording the marriage with the appropriate state or local government office.
Tom and I have been living together for 10 years, and everyone assumes we're married. Tom says we don't have to go through a ceremony because we're married under common law. Is he right?
He may be, depending on where you live. A common law marriage is a marriage that does not include a license or ceremony. Today, 14 states and the District of Columbia still recognize common law marriages. In these jurisdictions, a marriage will be recognized if a man and a woman agree to be married, live together, and present themselves to the community as husband and wife. There's no minimum period that the couple must live together for a common law marriage to be recognized. The same procedures for ending a ceremonial marriage apply to ending a common law marriage. The main difference is that when a common law couple breaks up, the man and woman often disagree about whether they've been married or not. The law is clear that both parties must have intended to be married at some point. But if one party later denies it, the intent can be difficult to prove. I want to emphasize that merely living together is never sufficient to create a common law marriage.
Alice and I have a common law marriage in a state that recognizes it as valid. We're about to move to another state where they don't recognize common law marriages. Will we still be married?
Yes, you will. If the marriage was legal in the state where it took place, when it took place, it will be recognized in states with different rules. This is a good place to explain an important legal principle. Two 17-year-olds who are considered married in Georgia will still be considered married if they move to any other state, even if that state requires that couples must be 18 to be married. The same is true of wills and other contracts. If a will was valid in one state at the time it was made, it will almost always be honored by another state, even if the other state has different rules. One exception to this general law is that if you simply visit another state to avoid certain prohibitions in your home state, the marriage, will, or contract will not be recognized.
I'm getting married soon. I run my own very successful business, while my fiancé has a less stable income and 2 children by his previous marriage. Should I consider a premarital contract?
People contemplating marriage often ask whether they should have a marriage contract. I enjoy pointing out that they'll have one if they marry, whether or not they write something down. Unless you substitute your own written contract, your marriage contract consists of the domestic relations law of your state as interpreted by its courts. Just as state law determines who gets your property if you die without a will, it also determines your marital obligations in the absence of a written contract between you and your spouse. There is one important difference, however. Wills are common, traditional, and encouraged. Marriage contracts, prenuptial agreements, and live-together agreements are still uncommon and aren't generally favored by courts or lawmakers. If these types of contracts ever need to be enforced, judges will examine them closely and refuse to enforce provisions that seem unfair, unreasonable, or contrary to public policy. The traditional vows to love, to cherish, for richer, for poorer, in sickness and in health, till death do us part, carry a much different tone than a detailed contract that lists property item by item, saying who can have what kind of bank account, and discusses alimony. To most of us, the former is romantic, rich, and meaningful. The latter is far too cold and calculating. It's arguable that couples who hold too much back from a marriage shouldn't receive full recognition of that marriage from society or the law. But with about half of all marriages ending in divorce, it just might make sense to provide for the possibility in advance. I'm aware that experts disagree as to who should have a written marriage contract. Some think all couples should consider one, while others would reserve them for special occasions or special situations. Such a situation might be where one party has adult children by a previous marriage and owns considerable property, and the other party is much younger. The older spouse-to-be may wish to ensure that his children inherit the bulk of his estate. Let me make one point very clear. Don't even consider writing a marriage contract without a lawyer. In fact, both parties should have their own lawyer. Here are some questions and issues worth thinking about. Perhaps you'll want to include some of them in your contract, in addition to whatever particular issue makes a written contract desirable in the first place.
Support of children, former spouses, and dependent relatives.
Paying for household expenses.
Dividing premarital property in the event of divorce.
How to end a business partnership between the parties.
What names the parties will use during their marriage.
How to modify or terminate the premarital agreement.
Your contract will also need to declare that you're both being honest about the property you own and that the contract isn't being made in anticipation of ending the marriage by divorce in the future.
I'm engaged to be married, but as the date draws closer, I'm less sure that it's what I want to do. I've tried to talk to my fiancée, but she says she'll sue me for breach of contract if I try to break the engagement. What are my rights?
First of all, agreements to marry may be broken at will. No court will force one person to marry another. With regard to the damages that your fiancé could sue you for, this depends on where your fiancé lives. The old rule was that the person left standing at the altar, whether the man or woman, could sue for breach of promise to marry, and if successful, be awarded damages for wedding expenses, loss of reputation, mental anguish, and so on. Many states, however, no longer allow someone to sue for breach of promise to marry. Other states that do allow such lawsuits have put various limits on them. If you are concerned about getting the engagement ring back from your fiancé, you probably shouldn't be. The general rule in most states is that gifts given in contemplation of marriage must be returned if the marriage doesn't take place. However, gifts given during a courtship but before a couple agrees to marry don't have to be returned. Engagement rings are given with the expectation that the marriage will take place. If you do decide to call off the wedding and your fiancé doesn't want to return the ring, you can go to court to try and enforce your ownership right. Your fiancé would probably either have to return the ring or pay you an equal amount to the ring's value. There are some exceptions to this rule. For instance, if the court found that you broke the engagement without good reason. In California, the rule is slightly different. If a woman breaks off the engagement, or there's a mutual decision to call off the wedding, then she must return the engagement ring. If the man breaks off the engagement, then the woman doesn't have to return the ring.
I'm very well known professionally by my maiden name. Do I have to change my name when I get married next month?
A woman's name doesn't automatically change when she marries. She can keep her maiden name, adopt her husband's last name, hyphenate the two, or even adopt an entirely different name. The key is consistent use. Adults are free to use whatever name they want simply by using it consistently, unless the name's adopted for a fraudulent purpose, such as causing confusion with someone else. Your name must also consist of a word or words. Symbols, logos, and numbers can't serve as names. No court proceeding is necessary. Just change your name on your driver's license, bank accounts, Social Security card, credit cards, and other identification, and inform your friends, relatives, and colleagues. If you do want to have a legal record of the change, all states do have a formal name-changing procedure available. It involves filing a petition, publishing your intentions in the newspaper, and attending a hearing. The formal procedure may be useful if the name you want to adopt is very unusual, or if you encounter problems with creditors or institutions. The clerk of your local court can help you with the details. So can your lawyer.
My wife kept her maiden name after we were married. Now we're about to have a baby. What last name will the child have?
A child normally gets the last name of its father if the mother and father are married. If the mother isn't married, the child gets the mother's last name, although the mother has the right to give the child its father's name if she wishes. After a divorce, a child retains its father's last name, and it can't be changed without a court order. If a father abandons the children by failing to visit or pay child support, a court may grant a petition to drop his name. This might also be permitted if the father were notorious and the name made life very difficult for the child. Otherwise, the father's consent is probably needed. Once a child's of legal age, that child can choose any name that he wants.
My boyfriend and I want to live together, but my parents say if we do, we'll be breaking the law. Are they right, Judge Wapner?
There was a time when they would have been, but not today. Not so long ago, it was illegal for unmarried couples to live together. Today it's legal in most states and ignored in the others. The law is changing as society changes, but it tends to lag a bit. The problems unmarried couples may encounter are with insurance and credit. In a medical emergency, authorities will be reluctant to allow the live-in partner to make decisions regarding treatment. Living together can also affect child custody and alimony. Ideally, unmarried couples who live together should spell out their financial relationship in writing, preferably with the assistance of a lawyer. Several highly publicized cases involving actors and athletes show what can happen otherwise. A written agreement isn't a guarantee that disputes won't arise if the relationship sours, but of course it helps. If a couple doesn't intend to be responsible for each other's debts and care, the partners need to be careful to keep separate bank accounts and maintain good records. Most don't do that. They don't plan ahead. Sometimes this is because they don't know what they want. Sometimes it's because the partners have different desires. Courts in these situations try to be fair, but it's hard to predict what a particular judge will find fair.
We've talked about the primary relationships to marriage and the ceremony itself. Before we turn to the issues that concern children and breaking up, let's spend a couple of minutes on a number of the aspects of marriage that involve the legal system. These include sexual relations, domestic violence, support, immunity, debts, and property issues. Sexual relations are a marital duty. However, the only remedy if a partner consistently refuses sexual relations is to end the marriage. One spouse may not force another unwilling spouse to engage in sexual relations.
Many states consider this type of behavior to constitute spousal rape and provide for serious punishment. All states will allow one spouse to charge another spouse with assault or battery in a case of forced relations.
Where domestic violence is concerned, violent marriage partners are finding that beating a spouse is just as illegal today as beating a neighbor. It is the crime of battery.
A related crime, which is known as assault, involves threatening imminent substantial harm to another person. Since a typical beating is preceded by a threat, both assault and battery are usually committed in one sequence of events. States are also beginning to expand what constitutes spousal abuse to include conduct that inflicts severe emotional pain.
My daughter's husband is very violent and has physically abused her on more than one occasion. She's called the police, but they haven't been a great deal of help. What's her next move?
Domestic disputes are among the most delicate of legal confrontations. Your daughter, or any other victim of abuse, should take the following steps.
First, she should get away from her abusive husband and not reveal her whereabouts.
Second, she should call the police if it's necessary to stop the abuse and try to calm the immediate situation.
Third, she should file charges, if she believes this is desirable, and seek a court order called a protective order, which will order her husband to stay physically away from her.
Fourth, she should get counseling and probably talk to the police, since laws, procedures, and standards vary from place to place and are constantly changing.
Finally, she should find one of the shelters which are available to hide battered spouses who fear retaliation.
Judge Wapner, I've lost my job and have been dependent on my wife for support for several months. She says it's not her responsibility since the man's supposed to pay for everything. Is she right?
No, she's not. Spouses are responsible for providing each other with what the law calls necessities of life. Necessities of life are defined as food, clothing, shelter, and medical care. Husbands used to have a duty to support their wives, who in turn had a duty to maintain a home but that's changed. One spouse generally can still use the credit of the other to acquire necessary items in most states.
I recently discovered that my husband has emptied a bank account that contained money I inherited from my parents. He had no right to the money, and I want to sue to get it back. My attorney told me I can't sue because of spousal immunity. Could you explain this?
The law traditionally considered a married couple to be one legal entity. Among the consequences of this doctrine was that spouses couldn't sue each other. The law has been changing for some time, but interspousal immunity still exists in some states. State laws on the subject can be grouped into three categories. A few states still bar all suits. Others permit suits for intentional harm, such as spouse abuse. A third group of states permit suits for unintentional conduct as well. This is particularly important in automobile accident cases. Please check your state's statutes.
Judge Wapner, can you tell me what a community property state is and how this affects property owned by a wife and husband?
There are two main property systems in use in the United States. Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin are the 9 community property states. In these states, property acquired during a marriage is jointly owned, no matter whose earnings were used to acquire the property. A non-working spouse has the same ownership interest in the property as the working spouse. The other states use the common law system. Each spouse retains separate ownership of earnings and any property bought with those earnings. Property that's separately titled, such as land and motor vehicles, belongs to the person named on the deed or title document.
When Bob died, he left a $10,000 Rolex watch to our son, John. 6 months later, John married Anita. Does she automatically obtain a half interest in the watch as a result of their marriage?
No, she doesn't. Anita doesn't have any right to the watch since John inherited it before their marriage. In a community property state, property owned by a spouse before getting married remains that person's own property. Also, property acquired after marriage as a personal gift or inheritance remains separately owned by the individual receiving such gift. Anything else earned or acquired by an individual during a marriage becomes community property, with each spouse owning a 1/2 interest in it. In all other states, anything acquired by a spouse's own efforts or anything acquired by a spouse through inheritance, both before and during marriage, remains the property of that spouse.
While I was on an extended assignment overseas, my wife used my credit card to buy a $2,000 color television. Am I obligated to pay for it?
The answer to this question will depend at least partially on your and your wife's past history with that particular credit card. If you had normally given that card to your wife for her use, you alone would probably be liable. Also, if your name alone was on the card application, but you gave her a duplicate for her use, you alone would still be liable. If both you and your wife signed the credit card application, however, you are both legally responsible for the charges she made. If your wife had used her own credit card for the purchase of the television, it's possible that you both may be liable depending upon the type of state that you live in. In common law states, one spouse usually isn't responsible for the other spouse's debts, except in certain situations. If both parties benefit from an expenditure, both may be liable for the debt. Spouses in common law states aren't liable for each other's pre-marital debts. If you live in a community property state, the situation is different. In some situations, one spouse may also become liable for his partner's premarital debts. My advice to anyone who's contemplating marriage to a debt-burdened person in a community property state is to definitely get legal assistance.
When you own property with someone else, you must treat it differently than if you owned it alone. For example, you can't give away something that isn't entirely yours without the owner's consent. This is why, when various belongings are jointly held, it's important to know which names appear on the title. There are 3 forms of joint ownership: two of which are commonly used by married couples in common law states. Joint tenancy with right of survivorship is a form of ownership in which each individual holds an equal interest in the commonly owned property.
If one owner dies, the survivor inherits the dead person's share automatically. If one owner wants to sell the property, the joint tenancy ends. The property must be sold, and each owner is given his share of the proceeds. In some cases, the second owner will resist the attempts of the first owner to sell the property. The first owner must then bring an action in court to terminate the tenancy. Joint tenancies are most often used for homes and bank accounts. You'll find more information about joint tenancy in my discussion on wills and estates.
Tenancy by the entirety is a special form of joint ownership available only to married couples in about 20 states. A tenancy by the entirety is similar to joint tenancy, particularly with respect to the right of survivorship. The major difference between these forms of ownership is that it's more difficult to end a tenancy by entirety. Either spouse may end a joint tenancy, whereas a tenancy by the entirety may only be ended by mutual consent of both spouses or by the death of one of them. A third type of joint ownership is called a tenancy in common. A tenancy in common is a form of property ownership available to anyone. An owner's share in a tenancy in common doesn't need to be equal, and an owner may sell his share separately. The major difference between a tenancy in common and a joint tenancy is that in a tenancy in common, there's no right of survivorship. If a tenant in common dies, his or her share of the property is distributed according to the wishes expressed in the will. Children are a core part of most marriages. In this segment, we'll examine the issues of reproduction, surrogate parenthood, paternity, adoption in all its various forms, as well as the rights and responsibilities of parents and children. The first issue is one of the most sensitive because it deals with a woman's right to reproduce or not, depending on her own choice. As of March 1992, a woman in the United States still has the right to obtain an abortion during the first 3 months of pregnancy. However, cases pending in the Supreme Court may soon grant states greater rights to restrict abortions.
All states are fairly free to restrict second trimester abortions. Final trimester abortions are available only to protect the mother's life. Husbands neither have the right to prevent a first trimester abortion nor to force their wives to have one. By the same token, a wife is free to ignore her husband's wishes regarding birth control.
My granddaughter's 17 years old and seriously involved with a young man. I'm concerned about her becoming pregnant. If she does, may she get an abortion without her parents' consent?
Possibly. But the approval of a judge may be required, and her parents may be entitled to notice of the prospective abortion. This remains a hotly disputed issue. State laws vary, and test cases are pending in court.
My daughter's been approached by an attorney to bear a child for another woman. She needs the money, but I'm concerned that it might be illegal for her to do this. Can you give us some guidance?
Serving as a surrogate mother is generally legal in most states, although your daughter should be careful about accepting money beyond what it costs her for medical expenses and prenatal care. The reason for this is that in most states, it is illegal for a surrogate mother to make a profit. In most surrogate situations, a husband's semen is united with an egg from either the wife or the surrogate mother. After being fertilized in the laboratory, the egg is implanted in the surrogate's womb. The surrogate mother carries the fetus to term and agrees to give up all rights to the child at birth. Traditional artificial insemination has been around for a long time and presents fewer problems. A husband who consents to his wife's artificial insemination with an anonymous donor's sperm is considered by law to be the father of the resulting child. The sperm donor has no parental rights.
My ex-girlfriend recently gave birth to my child. I never wanted the baby, and I've since moved out of state. Am I responsible for the support of the child even though I never married the child's mother?
The father of a child has a duty of support, whether or not he's married to the mother. If a woman is married, the law presumes that her husband is the father of any child she bears. Some states allow a husband to disprove paternity, while others do not. Sometimes the court may get involved in paternity disputes. Evidence of the relationship between a man and a child is usually determined using blood tests that are 98 to 99% accurate. Technology is limiting the need to compare photos, test other sexual partners, and cross-examine witnesses about dates and places. In most states, social service agencies can bring paternity suits on behalf of a child on public assistance so the agency can be reimbursed. At the very least, the father's support payments will replace at least part of the public support.
Adoption is the process by which an adult becomes the legally recognized mother or father of someone who isn't that person's biological child. It's a simple word, but it covers a wide variety of situations. For a childless couple, it's often a long, expensive, emotional process which involves their most basic hopes and dreams. In other situations, it can be a rather simple legal formality. Partly because of this variety, and partly because of recent trends in adoption, people often misunderstand what's involved.
Keep in mind, as I explain the different types of adoption, the child may have only one legal mother and one legal father at any given time. Therefore, unless one or both parents are dead, an adoption involves terminating someone's parental rights.
I want to adopt my wife's son by her previous marriage. The boy's father's dead. Is this a problem?
One of the most common adoption situations is just the one you've described. The spouse of a biological parent adopts that parent's child. If the second biological parent's dead, the adoption is a legal formality that will cost a few $100s and take relatively little time. If the second parent is unknown or has abandoned the child, attempts must be made to notify him. His parental rights can be terminated even if he objects or cannot be found. If one parent is remarried and has custody of a child, but the other parent is paying child support, adoption by the new spouse is unusual and can occur only with the absent parent's consent. Adoption in this situation would end the absent parent's support obligation, his visitation rights, and all other rights and obligations that he has toward the child. Somewhat more common is a situation where the absent father is known but isn't meeting his child support obligation. If the biological mother and stepfather believe that support in the future is unlikely, they may try to terminate the biological father's rights and have the stepfather adopt the child. Generally, courts won't allow such adoptions if the biological father is in contact with his child and isn't willfully refusing to meet his support obligation.
Another form of adoption is the related adoption, in which the new parent or parents were already related to the child. It's most common when both biological parents have died, or one of the biological parents has died and the other is missing. These adoptions often involve a relative who became the child's guardian, and that relative's spouse. Such adoptions are usually uncontested, quick, and inexpensive. The agency adoption is probably the most traditional route for couples seeking to adopt. Each state has a public agency that handles foster care and adoptions. The children under the agency's care generally aren't infants any longer, and a high percentage of them have special needs. The agency's services are free, but waiting lists are typically very long for healthy infants and younger children.
Another avenue of adoption is through a private agency. These agencies are licensed by the state to help match adopting parents and children. They traditionally maintain strict secrecy about the identity of the mother. Back when a majority of unwed mothers gave up their infants for adoption, the agency system worked fairly well. Today's society has become more tolerant of abortion and single-parent families. Therefore, the supply of healthy infants available for adoption has been severely diminished. By the 1970s, an infertile couple faced 60-to-1 odds of adopting a healthy newborn child. Agency standards for parents have increased dramatically, and their waiting lists have become longer and longer. With the growth of independent adoption, many agencies have turned to specializing in certain categories of harder-to-place children. Agencies' fees run from $1,000 to $10,000 and include a great deal of counseling.
My wife and I have tried the traditional avenues to adopt, but we've been told the waiting list is so long, we could be looking at a several-year wait. We've read about independent adoption through an attorney. Do we run any legal risks if we choose this option?
Arranging for an independent adoption is certainly another option for couples who want to adopt a child. In this case, the birth parents and the adopting parents make their own agreement with the help of one or more intermediaries. One of these is usually a lawyer. These so-called open adoptions now outnumber agency adoptions about 4 to 1. Open adoptions became popular out of frustration on the part of couples like you who are waiting to adopt and faced an inadequate supply of children at the agencies. Independent adoption used to be illegal out of a concern that this practice would lead to the selling of children. It's still illegal in 6 states, but even in these states, adopting parents may seek and meet prospective birth parents. Remember, it remains illegal in all states to pay a fee to the birth parents. A typical independent adoption involves a contract in which the adopting parents agree to pay all the birth parents' expenses in return for their agreement to give up the child. While the contract may be very specific, it may not be enforceable. Adopting parents run the risk that the birth parents will change their minds. Most adoptions of any type include a probationary period, often 6 months, during which one or both parties can back out.
My husband and I have been touched by the pictures of orphan children in other countries. What are the pros and cons of foreign adoption?
A foreign adoption is an agency or independent adoption of a non-American child by Americans. It's expensive and complicated because 3 sets of requirements must be met. Those of your individual state, federal restrictions, and those of the other country. Foreign adoption is an alternative for those such as single people or older adults who've had trouble either qualifying for an agency adoption or finding birth parents who will work with them.
Can I adopt a child as a single person, or if my partner and I are unmarried?
In most cases, yes. Although state laws and the policies of adoption agencies generally make it more difficult for anyone outside of a traditional marriage to adopt. Many courts take the view that a child's well-being is best served by having a mother and a father.
Can any attorney handle an adoption, or do I have to find a specialist?
Any lawyer who practices family law can usually handle an uncontested step-parent or relative adoption. But if the adoption is contested, the lawyer probably should be a family law specialist. If it's an independent or foreign adoption, you'll also need a family law specialist. The primary intermediary may be a doctor, family counselor, clinic, or agency, in addition to the lawyer. But an attorney must be involved. The legal issues in these procedures aren't primary, but they are important. I want to give you one final word to those of you contemplating adoption. Most people who are looking for a child to adopt have already been involved with numerous medical and social service professionals and have access to several referrals. You should exercise the same judgment in evaluating these referrals as you would in hiring a professional for any other purpose. Don't let your desperation, frustration, or anxiety change your standards. Don't hire anyone you don't feel both comfortable and confident about.